Hello and welcome to yet another podcast episode of Cradle Point Path to Parenthood. Today we will be talking about adoption and surrogacy. So doctor, to begin with, can you just please give us a small brief about surrogacy before we start in about the surrogacy and adoption?
Definitely we shall. But before that, I think I would like to congratulate Wiley, who's taken such a wonderful initiative, I would say, to connect the doctors, the legal people, to make it so simple and make it understandable to the common public. And I think that's an excellent thing that you people have been doing. And this is a very good topic that you have chosen to talk about surrogacy. You must be wondering what is surrogacy. So what happens here, there are a lot of couples who really want to become parents, but for medical reasons, various reasons which we will discuss as we go on, and they're not been able to have a child. They're not able to, carry a child in their womb and become parents. So this is when we have a third person coming into the whole scenario, helping this intent couple to carry the child on their behalf, to make sure that the couple is gifted a child on behalf of her. So this person who is volunteering to help this intending couple, we call her as a surrogate.
Now, Dr. Jokar, actually, off late, surrogacy has become more like a fashionable thing because all celebrities are endorsing it, and it looks as if just you have a problem and you can just get a surrogate mother. Before we start discussing about surrogacy, is there something that we have to know about the legal perspective of surrogacy?
Yes. To begin with, I personally welcome this particular collaborative endeavor of Government of Karnataka and NewsFirst. For the simple reason, there is a deserving need to create awareness about different pathways leading to parenthood, namely surrogacy and adoption. Dr. Lavanya very clearly explained about what constitutes surrogacy. Prior to 2021, there were attempts to create legal framework in this country, but could not succeed. But 2021 onwards, we have a Surrogacy Regulation Act and subsequent rules of 22, 23 and very recent 2024 are enforced. I just want to supplement what Dr. Lavanya said. Not having progeny is not only a social, cultural, but an emotional issue. And for many, the associated taboo and stigma, more particularly for women, is something inexplicable. Therefore, the law, while balancing the needs for having a parenthood, facilitating parenthood through surrogacy, also felt need for protecting the interest of the parents and the surrogate mother as well. That is how this particular legislation is conducted.
Okay.
The chief purpose of this particular legislation is to prohibit commercial surrogacy and facilitate altruistic surrogacy in a particular regulated manner. That is how the entire law has been framed.
I think that is more important right now, because considering the fact that everybody feels surrogacy is too easy, they should know that there are a lot of laws to be abided before they actually get into surrogacy. Now, doctor, now since we're talking about surrogacy, how do we evaluate a surrogate mother? Like, what are the health screenings that has to be done before she actually gets into become some surrogate mother?
I think that's a very valid and very important question to evaluate the surrogate mother, because she's volunteering herself for something which she's not supposed to be doing. She's doing it as a courtesy kind of a thing. And here there are no monetary benefits for her as well. So she's just trying to help these people. So it's our duty as a clinician to make sure this lady who is volunteering, that she is healthy, first of all, to carry a child. She remains healthy throughout her pregnancy, and also makes it more an important part that the intending couple are taking care of her. So coming to what all evaluations would we do, or how do we know this lady is fit to go ahead to carry the pregnancy for the couple. So while she comes in, first is an age criteria which is very important for us, where we see that she is anywhere between 25 to 35 years. That's something very important for us. We also see that she is married and she should have one living child which is supposed to be healthy. And this comes to our overall thing that she has a happy relationship by herself and she has a healthy child. Now coming to her health per se, we will be looking into simple investigations which is regular but mandatory, like a hemoglobin. We need to make sure that she is healthy. So a hemoglobin test will be done, her thyroid evaluations will be done, her serum prolactin will be done, a lot of hormonal assessment will be done, her blood sugars are checked. Is it, overall 3 months average sugar, HbA1c is done, serology like HIV testing, HPSAG, VDRL testings are all done to make sure that her kidney is functioning well, her liver is functioning well. We also see to it because, pregnancy is something, a lot of physiological changes happens in her body. Is she fit? So we need to assess the heart as well. So ECG is done, echo is done to see is her lungs functioning well. So chest x-rays are done. Sometimes it's very important. Some people are carriers called thalassemia. So all these things are also done for them so that she remains healthy and we make sure that the pregnancy is going to go through much better for her.
Okay. Now, doctor, what are the legal considerations that an intended couple should know before they actually enter into the surrogate agreement?
Before I delve into the response to this specific question, 2 observations I want to make. Under the law, surrogacy is not a matter of choice. Surrogacy is a matter of medical necessity. This is something, a very important revolutionary change that has come into being by virtue of this 2021 legislation. Number 2, our inputs, Dr. Lavanya's and my inputs, are not to be construed as either medical or legal or medico-legal opinion or advice. Our endeavor is merely to share information about the law with a larger objective of creating awareness. Now coming specifically to the question, there are multiple factors which need to be taken into consideration when we talk about the legal considerations which the intended parent should be aware of. To begin with, let me introduce 4 important phrases. One is altruistic surrogacy, second one is commercial surrogacy, third one is intended parents, fourth one is surrogate mother, about which Dr. Lavanya has already explained. Now, when we talk about altruistic surrogacy, according to the definition of this particular law, it says it is out of natural love and affection only, without seeking any kind of commercial or monetary return or benefit. Therefore, barring covering medical expenses, related expenses, maybe with regard to food, shelter, accommodation, etc., or some other expenses, but not any other commercial. That is something very important. Commercial surrogacy is also defined either in kind or cash or benefit or property, mobile, immobile, anything, either to her or representative or heir or spouse or parent, no question of. And if at all there is a commercial surrogacy, it is an offence for which stringent punishment is prescribed for.
Oh, commercial surrogacy is
absolutely prohibited.
Okay.
Now coming to the third one, intended parents. Intended parents, particularly the question also is very clear. What is that they need to look forward to? Intended parents, please remember, by virtue of this law, either of the spouse is not allowed to avail surrogacy. Only a woman who is either divorcee or widow can only avail surrogacy, which means the intended parents must be legally married. The institution of marriage, which is validated by the legal process, is one of the very important point which requires to be taken. Similarly, the law provides for the age factor, particularly for women, the age between 23 years to 50 years, and male between 26 and 55 years. One more, the intending parents must not have a child either through adoption or earlier surrogacy or biological child, unless such child is either physically or mentally compromised or suffering from a disease or mental retardation or something which is incurable in character. All these factors must be prima facie mandatorily followed. Then only the intended parents are entitled to go for the surrogacy. Number one. Number two, as Dr. Lavanya very rightly said, surrogate mother, there are three important factors. Not only the age of 25 to 35, but one important thing, she must also be legally married. And she must have one child. And she can give a surrogate child only one time in her lifetime. And for which she can only be subjected to surrogacy processes only 3 times, not more than that. This is what the law, considering the best interests of the woman and of our own experiences of lot of exploitation which we have read it in our media, etc. Then comes the most important thing is the intended parents must have the medical necessity. Please remember, it is not I don't want to bear the child, therefore I want to go for surrogacy. Those days have gone. It must be a medical necessity either of the spouse or both of the spouses. Medical board must give a certificate. That is what is the certificate of essentiality. Similarly, they are eligible, the age factor, not having a child, etc., etc. When these two things are there, even the surrogate mother must be subjected to a very important process which I personally endorse, that she is physically and mentally fit to undergo surrogacy process. That is the responsibility of the intended parents to undertake. And finally, there is one more thing, that is the surrogacy clinic where the surrogacy procedure is going to take place. The clinic must comprehensively comply with all the regulatory features, either regard to the institution, infrastructure, doctors, equipment, documentation, processes, etc. I think all these things provide a very balanced approach. On one hand, regulating the altruistic surrogacy, at the same time protecting the interests of intended parents. Finally, intended parents, by virtue of this surrogacy contract, they are legally entitled to have the child born out of surrogacy as their own biological child, and they have to go and get the permission, a written order from the magistrate court, and accordingly that becomes the legal birth affidavit. I think that's all the consideration.
Very interesting, doctor. Even in normal pregnancy, there are a lot of complications. How is it in a surrogacy arrangement?
So it is a similar thing because the lady is going through a lot of physiological changes. So pregnancy per se will lead into a lot of changes in the women's body, which we are all aware. So like any other normal pregnancy, the surrogate is going through the same pregnancy process for somebody else. So she could be at a high risk of developing hypertension, she could be at a high risk of developing diabetes or some cardiac ailments. This is exactly why we need to evaluate them, make sure they're in the pink of the health. Only after evaluation and they're certified that they are capable of going through a surrogacy, that is when they go through it. This is why it is necessary that all the certification is done, the fitness is done. It's not only about physical fitness, it's also very important that they go through a psychological counseling and they're certified by the psychologist as well, because here at some time there could be a lot of emotional changes which happens anyway through the pregnancy, and now she's being a surrogate. So we also need to make sure that mentally she is fit, psychologically she is fit, and she needs to be certified to going through this surrogacy. So it's not only physical, it's also emotional and psychological certifications needs to be done.
What are the laws which protect the intended parents as well as the surrogate mother throughout the process of surrogacy?
I think law clearly envisages certain aspects, but before I delve into this, just to supplement Dr. Lavanya with regard to the question you have posed pertaining to the medical complications. I think your question is very, very relevant and significant because medical complications do not literally discriminate between either birth is through surrogacy or something else. A woman bearing a child, having and delivering, complications may come about. I think law very clearly, in a very, very graceful manner, mandated that the intended parents must take an insurance policy covering the possible risks and complications which the surrogate mother may face, not only for 1 year, for 36 months from the date of delivery. And according to the insurance policy takes care about. I think that's how the interests of surrogate mother have been, particularly medical complications. I mean, I don't think anyone will be able to really, we may foresee, but we don't know whether it happens or not. That unpredictability is built in. I think to that effect, a very important thing. Now coming to the processes of protecting the interests of the, one important thing when we talk about surrogate mother is that because commercial surrogacy is prohibited, the surrogate mother cannot be subjected to any kind of exploitation, either by intended parents or sometimes surrogate mother's spouse or mother-in-law or other family members, etc., because she becomes the vehicle to get finance. That must be, therefore, that is something very clearly provided. Similarly, the most significant, that's what I think, as a matter of womanhood, she is entitled to withdraw her consent for being the surrogate mother before the embryo implantation. She may give consent, she may sign, but before the date of implantation, she is absolutely entitled legally to withdraw her consent. That way, her interest has been protected. And thirdly, I think very, very significant one, under no circumstances, surrogate mother can be either coerced or pressurized to undergo termination of pregnancy or abortion of pregnancy. I think that is something. Similarly, very important thing is the surrogate mother must be clearly informed about what are all the procedures, as Dr. Lavanya mentioned, the woman will be subjected to, what are the possible side effects. In the language she understands must be explained, counseling, and there is a detailed informed consent form she has to. And finally, under no circumstances, any kind of pressure can be put on surrogate mother. Please remember, on one hand, she cannot be coerced to abort the, but on the other hand, if there is a need, if there is a need for abortion on account of medical complications, she must be given that right. I think that's how the law balances both and protects the interest of the surrogate. And when it comes to intended parents, the most important thing is, after the delivery, the surrogate mother has to hand over the child to intended parents, and they become the biological genetic parents, and the child is entitled to all the inheritable rights of the parents. Secondly, the most important one is, because the surrogacy can only be undertaken in a clinic which completely complies with law and regulation, the interests of intended parents are protected. Finally, surrogate mother cannot claim the custody of the child after delivery. That is something in the interest of the intended parents.
Doctor, you were mentioning about thalassemia and all that. How important is genetic screening for the surrogate mother? Because I have a small doubt, like, if the baby is in a particular surrogate mother, will the baby inherit their genetic genes or something?
Not necessarily. Here even the thalassemia testing is done because most of the thalassemia patients, the hemoglobin is very less. If you're not evaluating unnecessarily, you're overloading them with the iron medications, and then you see that the iron is not picking up, you're going to give them IV fluid, and you start giving them intraparental IV injections, all these things. So this is why the evaluation is very important. Per se, the genetic diseases do not have to be evaluated from the surrogate mother, because she's not passing any gene to the baby which is growing. Here we need to understand, when we're talking about a surrogate mother, she's having the embryo after an IV of the intending couple. So it genetically does not belong to the surrogate mother. But where would a genetic testing be important is, we do the genetic testing for the embryo even before we transfer. We call this as a pre-genetic testing to rule out, is there any aneuploidy in the embryo, so that we transfer the healthy embryo, so that the surrogate mother don't have to go through any of the termination process like sir mentioned. See what happens, you're doing, now you've evaluated, you've done a PGTA testing, we have confirmed that it's an euploidy embryo, that means it's a normal embryo which can have a very good implantation rate. Sometimes it does happen, we have a failure chance of almost 20% that we do a embryo transfer, she's not able to conceive. Then she can take a break and we don't have to do any extra testing on her because already evaluation has been done on her. So we can restart and do another embryo transfer where the finances are very minimally involved because she's already been evaluated. Now luckily if she conceives, regular ANC checks are important. This is how we come to know does she carry a healthy baby. So 3-month scan, AT scan, NIPT testing, if required amniocentesis, 5th month anomaly scan, all the antenatal check has to be done per se that you would be doing it for any other pregnant women. So all these things have to be carried on. So genetic testing per se for the surrogate mother is not required. Genetic testing for the embryo is must, and again only if the intending couple have gone through previous lot of recurrent implantation failures or recurrent pregnancy losses, then yes, all the evaluation, but not per se for a surrogate.
So it can be done before implantation
Yes,
itself
it
for the
definitely
baby.
has to be done before even doing the embryo transfer.
Okay. So you'll know much before.
Yes, we know if it's an healthy embryo. So this is how we choose, because so many times the intending couple have gone through an IVF procedure. So we may get around 8 oocytes. Now we fertilize. All the 8 oocytes will not be converted into an embryo. That means it's not going to become a baby after fertilizing the egg and the sperms together. Now in this, imagine we get a 5 embryos. So we do testing for these at day 5 embryos we call it. So when we do a testing, we know are they really good embryos or not. So we know that we are not passing on any abnormal babies, or they do not have any syndromic babies. So we know what is healthy because nature itself is so beautiful. If it's not a healthy baby, most of the times uterus rejects implantation, doesn't happen, or at later stages they go through an abortion. To prevent these things for the surrogate mother, because she's acting here as a help to the intending couple. So better to do a testing and then transfer.
But so far in your experience, doctor, how has been the surrogacy percentage of the success rate probably with healthy babies? Is it been like 100%?
Yes, we cannot call it 100%. I always tell my patients, especially fertility doctors, we can only play gods, we cannot become gods. So we are creating babies in the lab. Right. But then once the baby is transferred, I think we are all at the mercy of the god. And there's a lot of embryo endometrium talk which happens, cross talk which happens between the embryo and the endometrium. So implantation is at the mercy of the god and our prayers. But why in surrogacy we have a much higher success rate is because we need to understand she's in the right reproductive age group. She's a healthy woman because she's already delivered one healthy child. So this is why her success rate of having a better implantation and carrying it to the term is much higher compared to anybody else.
Okay. Because generally in normal pregnancy, it's only in the 5th month that they actually screen for genetic disorders and all.
But now we have fantastic screening modalities where at the 3rd month itself we can do NT scan, we get to know if there are any aneuploidies, nuchal translucency changes are there. Genetic testing can be done as much as early as the 3rd month.
Now doctor, after the surrogate mother has given birth to the baby, if she does not want to give it to the parents, how does the law protect the intended parents?
This is a very interesting and important question. The moot point in this regard is, on one hand, the law facilitates surrogate mother, in case if she wants, she can withdraw her consent to act as surrogate mother. That is before implantation of embryo. On the other hand, the law mandates that after signing the surrogacy agreement, after delivering the child becomes the legal heir of the intended parents, and they are only entitled to the custody of the child, and accordingly the surrogate mother cannot withdraw post delivery. That is something she has to. Suppose, we are not talking in terms of contracts, but we are talking about mother and babies, the underlying relationship. Maybe a mother, surrogate mother, may come to a conclusion that I cannot part with my child. I might have entered into an agreement, etc., but now I cannot. Suppose in the event of such a kind of situation, the law protects the interest of the intended parents, because prior to 2021 Act, there were certain decisions either in first world or our own context where they said the relationship between the newborn and the mother cannot be couched in a legal contract. That is entirely different. How can anybody decide whether I will be able to part with my child or not? I am not the mother. That's what judge said. I am not the mother. I don't understand. But mother understands. I think to that effect, the law did provide the mechanism to give the custody of the child to the intended parents. Because here, however, because it's a very recent legislation, if at all there is such an issue, it would be a very interesting interpretation which we have to wait and see how the courts will be able to do that. Either to give importance to the emotive cord between the mother and the newborn, or the intended parents who entered into a surrogate contract which is legally valid. I think that will be a very interesting.
What do you feel as an
I think the surrogate mother must be given the ultimate option.
But the intended parents also will have a lot of hopes.
I think there are no other third option for us, either this or that. When it comes to intended parents, I personally feel they may be given another opportunity with another surrogate. But this, if at all it happens, I know it is contrary to law, it is clearly a breach of contract, but somewhere down the line my heart goes for the surrogate mother. That's I'm not answering like a lawyer, as a lay person.
Yes,
I am
yes.
saying the relationship.
Doctor, as you said, it is not 100%. Now, how do you take care of the well-being of the intended couple as well as the surrogate mother throughout the process, in case there's a failed surrogacy also?
Yeah. So that is when very much important, like I mentioned in the beginning, where we are trying to evaluate the couple as well, and it's not just the surrogate well-being that we were looking when I said, physical, emotional well-being of the surrogate mother. It's also the emotional well-being and the psychological well-being of the intended couple also. Because what happens here, like sir mentioned, it's such an emotional journey that the surrogate mother is going through the pregnancy. Since the intending couple are not physiologically going through it, sometimes that bondage may be a little difficult. So it is also very important that they are in constant touch with the surrogate mother. They're taking care of her. Nutrition is also very important. It has to be addressed, and this is why a regular visits to the clinician where the nutrition assessment is done, blood investigations are done, scannings are done, and regular weight check, BP monitoring, everything is done. Regular intervals of screening like urine test to see, is there any changes in the albumin, infections. All these things have to be, evaluated to make sure that the surrogate mother is healthy. In the same way, we are always trying to get, because this is the contract between the intending parents and the surrogate mother. Sometimes it's a relative or somebody whom they have chosen and they're volunteered. So here the intending people are always with her. So they go through the journey together. It could be simple Lamaze classes or some exercise, antenatal classes. So the intending couple can also attend through the surrogate mother, and this is how the bondage develops. And I think it's a beautiful journey of all the three of them together, and should be taken.
The parents, intended parents, can be throughout the pregnancy. They can with the surrogate
because
mother.
This is somebody, a surrogate has volunteered herself, and this lady is being brought in by the intending couple. So they are always in constant touch, and especially I think nutrition has to be taken care of this surrogate mother who is volunteered. So taking care of her health and making sure that she is healthy is very important, and that is how indirectly we are only going to get a healthy child. So.
Okay. Now, doctor, is there any legal binding contract which helps all the parties, like the surrogate mother as well as the intended parents?
Yes. In fact, the 2021 Act mandates that intended parties on one hand, surrogate mother and other members of the family, particularly her spouse, etc., they need to execute a valid binding surrogacy agreement or contract. That's number one. When what it contains, first thing is, the most important thing, the surrogate mother must be clearly explained about various procedures which she would be subjected to. As a mother, she delivered already one child, that she understands. But IVF related, she may not be able to understand. Therefore, all the things must be explained to her in the language here. Second important thing is, they need to be, biological, need to be screened for HIV, hepatitis C, hepatitis B, or any other sexually transmitted diseases. to protect the interest of not only the parties, including the baby to be born. Then comes, because a commercial surrogacy is prohibited, the medical expenses relating to nutrition, accommodation, weekly or periodical visits to the gynecologist, all those things need to be taken into consideration. Then comes, intended parents must provide health insurance policy for the surrogate mother for 36 months post the date of delivery. Then comes, in the agreement, the surrogate mother must clearly say and undertake and submit that she is going to relinquish her rights over the child after the child's birth. I think that is something, as I told you, there is a very peculiar emotive issue, but I think she signs on account of altruistic nature that she would be serving as Dr. Lavanya, as a matter of help or a courtesy to a childless couple. Then comes, under no circumstances, surrogate mother can be subjected to any kind of responsibility for whatever type or child that she delivers. She may deliver a child with a particular problem or some other disease or some other. She cannot be subjected to. Similarly, surrogate mother cannot be subjected to, unless it is so warranted, sex determination test. Because in this country, along with various other problems, we have a serious problem of SDT, because preference to the boy still continues. No doubt there is a change, but that's not perceptible change. Then finally comes, surrogate mother or her parents, spouse, etc. cannot be subjected to any kind of exploitation. Because on one hand, altruistically she is coming forward, that must be respected, only for medical expenses and related expenses only. I think these are the various terms and conditions, apart from others, which protect the interest of both intended parents and surrogate mother and her family as well.
In spite of all this, if there some dispute arises between the intended parents and the surrogate mother, how can it be solved?
Definitely it is a matter of civil suit. It's a contract. It is a legal and binding contract, and accordingly a civil suit has to be filed, depending upon. Suppose if the surrogate mother doesn't want to part with her child, then they will file case for having, because they have rights as per the contract, the child must be given custody to be given to them. Or whatever said and done, intended parents have agreed, but they don't bear the medical expenses. They are not subjecting surrogate mother to periodic checkups, etc. In such a case, she can file a case, etc. But more importantly, what the 2021 Act says is a perennial problem in this society. Reasons are many, that's a different matter. Nobody can abandon the child. Abandoning the child is the simplest way many people prefer. Abandoning the child cannot be the result, either for intended parents or for the surrogate mother. And in the light of which, considering the best interest of the child, the law provides various mechanisms. That's how the interest.
We'll just take a small break and be back with a topic with our doctor.